oversight and regulatory authority over all criminal and family court probation in New York State. We also have oversight of over 150 alternative to incarceration programs throughout the state, primarily with a large number of them being operated in New York City. We have a very active training component within our office. Main focus is to complete a fundamentals of probation practice academy for all new probation officers, which they have to complete within 6 months of regulation. We also have the ignition interlock device unit within our office, and they monitor and maintain and system regulation for all the ignition devices that are installed by vendors throughout. Lastly, most importantly for purposes of this meeting, we had an Interstate compact unit in our office, headed by Kelly Palmentier here, and that is the oversight of probationers who are transferring either in or out of New York State. Our office manages those. We have no direct supervision within our office, a little bit different from what Scott will tell you about. But we manage the transfer process, and also located in our office is the compact administrator and interstate commissioner for New York State, who's really kind of responsible for both parole and probation transfer. So, I will pass it to my right. I guess. John.
Sure. John Watson, usually last to be called. Counsel to the State Office of Victim Services, formerly the Crime Victims Board, the second oldest of its kind in the country, established in 1966. We're the state administering agency for the Department of Justice's Office of Victims of Crime, VOCA Victims of Crime Funds. We serve a two-tier purpose related to that aspect by providing victim assistance grants to over 200 local victim assistance programs across the state, and providing compensation reimbursement for eligible crime-related losses. We've been around for, as I said, over 50 years. I've been around since it was a Crime Victims Board. I'm going on 18 years now. So if you knew before, it's no surprise.
And John has been very kind enough, and always is kind enough to sit in for the new director at the Office of Victim Services, B. Hansen.
B. Hansen comes to us from New York City. She was with the mayor's office of gun violence, and prior to that, served in numerous. Actually, served at the federal level and at the state level as an advocate for victims of crime for quite some time. So we're happy. I'm happy not to be the lightning rod for the agency.
Appreciate it. Lisa?
Hi, I'm Lisa Good. I'm the founder and director of Urban Grief. Grief is an OBS funded program. Thank you. Under the umbrella of Trinity Alliance of the Capital Region, and I am the victim rights representative.
Thank you, Lisa.
Thank you, Chair. Hi, everyone. I'm Senator Julia Salazar. I represent New York's 18th District, which is in Brooklyn and Queens, and I am the chair of the Crime Victims, Crime and Correction Committee in the State Senate.
Good morning, everyone. I'm Edwin Novillo. I'm currently an acting justice in the Supreme Court in Queens County. I've been a judge for about 7 years, almost 7 years. I spent 6 years in criminal court, and this is my first year up in Supreme Court in Queens County. And I'm currently a judicial appointee. So anything I can do to help, please lean on me.
And welcome to our newest member. Thank you. Thank you.
My name is Scott Hurto. I'm the Bureau Chief of the Interstate Office for the Department of Corrections, Community Supervision. Like Matt said, we monitor all parolees coming in and out of New York State. Some probationers, depending if they fall under our memorandum of understanding. Our office also has oversight of parolees incarcerated out of state and other facilities, and all parolees that are deported out of the country. I'm also the deputy compact administrator for parole. I don't know if I mentioned that.
And Scott is the designee for the docs commissioner and Marchisella.
Yep.
Scott?
Hi, everybody. I am Shayna Kern. I work in the Interstate Unit in the Office of Probation and Correctional Alternatives in DCJS under Kelly and Matt, and I'm a supervisor in the unit. I mainly handle the adult sex offender and DV caseload at the time, problem cases, assist our staff, also the juvenile compact. I'm the deputy compact administrator for our juvenile compact.
And I'm Kelly Palmetier. I'm the manager of the Interstate Compact Unit here at OPCA. DCJS's OPCA. As Shana said, we manage the movement of individuals who are on probation supervision across state lines. We do that through the Interstate Compact for Adult Offender Supervision, but also New York is signatory to the Interstate Compact for Juveniles. So we do manage both caseloads, and that's about 5,500 cases, interstate cases that we are managing.
Thank you, Kelly. And unfortunately, I think stuck in his car or on his way out of New York City or somewhere located in New York City is the New York State Board of Parole Chair, Daryl Towns. Daryl, I'm not sure if you can hear us.
Yeah, I'm on, Matt. Thank you very much, and good morning, everyone. Sorry I'm not there today. I woke up a little under the weather and thought it'd be smarter for me to join by phone. Just let the senator know all is well in the 18th Senatorial District.
Thank you.
Thank you, Chair Towns. Just a little bit about the council. I mean, the council is designed to be advisory to the compact administrator. It tries to bring key stakeholders from various levels of government and community together. Mandatory for this council, we have 4 legislators that are required to be part of our council. That's 2 from the Assembly, 2 from the Senate. Missing today, but always a big supporter of this council, so Senator David Wetbred, who has been with us for a while. We're hoping to re-up his nomination, so we want to keep the Assemblyman here because he's been, as I said, a big supporter. We also have part of our council is Senator Eric Milan, and in the Senate we have Julia Salazar, also been one of our biggest supporters in her tenure here, much appreciated. Our other Senate position is open, and we will be moving to try to fill that. The judicial nominee, welcome again, Judge. Appreciate your work. We have from the community a victim rights representative that has to be part of our council, and that's Lisa. And Lisa's work in her area is pretty amazing. Another person we have to have on the council is the Office of Victim Services Director. And as I said, John is here representing Director Hanson. The DCJS Commissioner, also unfortunately not able to join us today, is a member in the Office of Probation and Correctional Alternatives Director, which is I'm acting in that capacity now. And the docs Commissioner also, Scott is here. So that's kind of the makeup of our board, of our council. And again, we bring stakeholders together to talk about issues that are relevant to interstate compact, interstate transfer. And they're really the council's job is to act as an advisory and to be helpful in to DCJS and really addressing some of the compact issues that we may face as an office. And I must say that, the membership today and the membership in the past has been very, very, very good at doing so. I was just telling you, Judge, he's got big shoes to fill. Judge Yavinsky down there, is he still in Kings?
In Queens with me now.
In Queens with you, so.
Acting Supreme.
Yeah, so it was very helpful when we had some issues down in New York City with getting some stuff processed through the courts, and he really expedited that process and was really helpful. Actually convened a group of all the relevant court clerks down there where we went down and spoke to them, and it was very helpful. So that's really kind of what we want. We've recognized that, a lot. I was telling Judge, the Interstate Compact, he's probably first thing he said is, "What the heck is that?" I don't know, but I think a lot of people react the same way. We realize, we're not experts in that area. That's why Kelly's here, Scott's here, they're the experts. But we do reach out and lean on council members to provide us some assistance when we need to, and certainly want to take our direction from the council. Really, that's what you guys are here to do. So please be comment, ask questions. That's what we're here for. We really want to lean on the council moving forward. Additionally, I will say this is us talking, council members kind of fulfilling their appointments, sitting and listening, really helpful. But we really want to encourage the council membership to really be active and participate in the meetings and really be that true advisor to the compact administrator, which is where we'll be brought this council together. So, any questions? All right. So you have it. Everybody has an agenda in their package. So Kelly, Steve, for putting this package together. You can take a look at that. Well, I'm not going to ask for an official vote on the approval of the agenda. Whether you know that's there, so you can see what we have planned for today. We do have a 2-hour meeting scheduled. I believe it's going to take 2 hours to complete the agenda, but certainly we are here for those full 2 hours. We need to be. Also, in your packet are the minutes from Thursday, May 16th, our spring meeting. If you guys can take a minute, if you have not done so already, just take a look at them. We'll have to see any amendments to that. But the minutes will certainly introduce you. Any questions? Approving the spring 2024 Thursday, May 16th, 2024 minutes as they're written. Senator Salazar. So thank you for that. Minutes are approved. What we like to do every time we meet is read our mission statement. And Kelly usually, I ask to do it. She gives me a lot of grief about it. She doesn't want to read the mission statement. And Scott, unless you're ready to step up, I will go ahead and
Go ahead.
All right. The record reflects Shana Kern.
All right, everybody. So our mission statement here is the mission of the New York State Council for the Interstate Compact for Adult Offender Supervision is to serve as an advisory body to the State Compact Administrator and to make recommendations for the implementation of state policies and procedures that facilitate the effective tracking, supervision, and rehabilitation of individuals under community supervision, advance their orderly transfer across state lines, and promote public and victim safety.
Thank you, Shana. Appreciate that. Any questions on the mission statement? We've made some tweaks to it over the years. Glad that the membership is improving on it. The next thing we do, we talk about is every time we get together, we look at compliance. And so the Interstate Commission is made up of a representative of every state and 3 territories in territories DC, which is a district, Puerto Rico, and the U.S. Virgin Islands. And so that's the one representative state and territory. That they come together maybe once a year, and Kelly's going to talk a little bit about that meeting a little bit later. But one of the committees of the full commission is the compliance committee. And the compliance committee's main job is to make sure that all states are acting, complying in accordance with the interstate compact rules, which I think we've given those out before. You'll know it's a big thick book of rules. I promised Judge that he's going to get the bench book, which is the rules and some commentary for judges. But they do, the compliance committee does audit New York State on a quarterly basis to make sure that we're compliant with 6 different areas within compact business. They also look at practice by states, which we'll talk a little bit more later. But one of the things we do every time is to see where New York State is compliant in those 6 key areas. And I think in your packet you have a colored overview. It looks like this. And Kelly's going to go through those to tell us where New York State stands in relation to those compliance measures. I will say this. New York State is probably, it's kind of vastly, it's somewhere between the 7th and 8th largest as far as compact business in the commission. We struggle. One of the things we struggle with is the New York State probation is administered at the county level. So it's not like county probation departments are DCGS employees. They're county employees who work for a director who's appointed by the governing board or authority in that county. So it's sometimes like, trying to herd cats with probation departments and getting them to comply with the measures of the interstate compact. And again, interstate work it's a kind of a very specific science within the whole world of probation. So sometimes probation officers struggle in understanding the rules and understanding some of the practices alongside of that. So on our side, on the probation side, I know it's very difficult. I think traditionally, Scott, they recognize that they have a little bit more control and authority over some of the field offices and in parole. So it is a little bit easier to do. But I just want to recognize both the work that Kelly's unit and Scott's unit do within the respective agencies, because really we do a wonderful job of making sure we're compliant with these 6 key measures. But more importantly, we're approaching interstate compact with an understanding that generally people are just trying to get where they need to go, and we want to be helpful in making sure that we facilitate that process. So having said that, Karen, I'll ask you to go through a little explanation and go through some of those 6 matters.
Sure. You'll see 3 different sets of dashboards in your packet. There is one that covers New York State's compliance as a whole, including, both probation and parole numbers. I will go over probation. Well, I'll go over the state as a whole first, and then get into the probation specific numbers, and then I'll let Scott talk about the parole numbers if he wants to. So for New York State compliance, you'll see on the first page there are 3 different compliance measures that the national office is monitoring states on, as Matt said, on a regular basis. One of them is with case closure compliance, and that would be for New York State, any state or any case that has been transferred to New York State for supervision, that New York State is submitting a case closure for that case within 10 business days of the date that the sending state said the term of probation ends. So if probation ends today, we have 10 business days from today to submit the case closure in that case. So you can see, as Matt mentioned, the compliance threshold is 80%. So for New York State, we are at 94.87% in that area. The national average is at 96.52. For case closure replies, these are responses to case closure notices on probation or parole cases that we have transferred out to another state for supervision. So that other state would submit a case closure to us, and then as the sentencing state, we would have to validate that case closure and say, yes, the case can be closed, or no, it can't. So we, as a state, are at 98.26% compliant in that area. We have 10 days to submit that response from the time that we receive the case closure notice from the other state. The national average is 92.96%. With regards to progress reports, when the sentencing state requests a progress report from the state that is providing supervision, that state has 30 calendar days to submit the progress report. So for New York State, we're at 94.18%. The national average is 92.33%. So we're, doing very well in all of those areas. On the second page, you'll see the first column. I tried to print this in a different way. It doesn't allow me to do it so that the headings match the dashboard itself. But the first set of numbers is for reporting instruction replies. Reporting instructions allow an individual who's on supervision to be present in the receiving state while their transfer is pending. So the sending state requests that. The receiving state has 2 business days to respond to those requests, 5 business days if it's an individual who meets the definition of a sex offender. So as a state, we are at 97.69% compliance in that area. The national average is pretty similar, 97.26%. For transfer reply compliance, this would be cases that were sentenced in another state who are transferring to New York State. New York has 45 days to submit their reply to that transfer request, indicating whether or not they're going to accept or reject supervision. We are, as a state, at 97.13% compliant in that area. And the national average is at 95.61%. And then finally, the last set of numbers is for violation reports. So as the sending state, when the receiving state submits a violation report to us as the sentencing state, we have 10 business days to respond to that violation report to advise them on how we plan to proceed. As a state, we're at 97.78%. And the national average is 91.14%. So overall, New York State has, been in line with the national average or above the national average in all of those areas for the last year. This is from November 1st of 2023 to October 31st of 24.
And just so I can interrupt for just a brief second, and to put this in kind of real terms now, what it means to people, I often we'll talk about reporting instructions and transfer reply. I use this example a lot, so Kelly's heard it in a number of trainings. Well, let's say I go down to Florida and I get a DWI, a felony DWI, and I go down there and I'm convicted and I'm sentenced to 5 years of probation in the state of Florida. I can't be in New York State for more than 45 days, or if there's a transfer request pending, because I now have this conviction in Florida. So Florida, that court has jurisdiction of me, and so I've got to stay in that, in any, I can't stay there, but I can't be back in where my home is in New York State until New York State approved me from doing so. As Kelly said, transfer requests take 45 days to be reviewed and responded to. So reporting instructions allow me during that pendency to go, I can leave Florida and go immediately back to my home in New York State. Because I've got nothing in Florida, my home, my job, my family's all in New York State. I got to get back there immediately. The issuance of reporting instructions allow me to do that while that 45-day clock is ticking for the full transfer request. So now that I'm back in New York State, I'm waiting for New York State to look at my transfer request and officially accept my supervision. And I can remain there once that's done. So that's kind of where those two things kind of come in kind of real terms. Now, during the time I'm on supervision in New York State, Florida, who has jurisdiction on me, would like to know how I'm doing. Because they're in Florida, I'm under supervision in New York State, so they can ask for a progress report from New York State. So they want to know, how's Matt Chart doing under supervision? Has he completed A, B, C, and D of his conditions? Is he in treatment? Is he employed? All those things I need to be doing. So Florida can ask for a progress report. So you see why it's important for that 30-day mark to be met, because Florida really wants to know, and we should keep Florida in the dark for longer than they should be. Let's say Matt Charton gets another DWI while he's in New York State, and so that might trigger what's called a violation report or a violation required retaking. And so that is done through that process in the system. And now Florida has to respond to New York State. What are you going to do? Matt Charton just got arrested for DWI, just got convicted of a misdemeanor DWI here in New York State. Florida, what are you going to do? And Florida has a couple of options. They can issue a warrant and return me a warrant. They can order me to return to Florida to answer the violation that's in their court, or they can decline to do anything. No, they can't.
So they have two options when there's a conviction.
So that's why it's important that those measures are looked at, making sure that the states are being reactive to what that person under supervision is doing. And then the last one, the case closure notice and the case closure reply, that's just when my term is up. You need to close that case in the national system. That gives us clean data, and we want to make sure that once New York has requested the closing of the case, Florida agrees, yes, that case, and that's the case closure reply. So those kind of, to give a little bit of an example of kind of real life kind of reasons why these measures are taken a look at. That's why I'm just interjecting. So sorry to interrupt you.
No, that's fine, thank you. So I'll just move on briefly and talk about the probation numbers, and Matt touched on this when he was giving an overview of the compliance standards in the difference between probation and parole in New York State, and all of these documents, for lack of a better term, I mean that all of this information is submitted electronically, but it is all done by our local probation department. So any case closure notice that is submitted is coming from the probation department itself. It's not from our office. So we do spend a lot of time in our unit reaching out to probation departments, reminding them of due dates, telling them that, you have a case closure that's coming up soon that you need to have submitted. So we do have a lot of contact with staff at our probation departments to make sure that we are remaining above that 80% threshold in all of these areas. So this is just probation specific data now. With the submission of case closures, probation is at 93.95%. The national average again was 96.53. For case closure replies, we're at 98.83%. The national office is 93%. For the progress reports, so submitting those requested progress reports for people we are supervising for other states, we're at 93.17%, and the national average is 92.33%. For the response to the request for reporting instructions, we're at 97.63% in that area. The national average is 97.26%. For the replies to the transfer request, that means we're submitting or our acceptance or denial within the 45-day time frame that we're allowed to investigate. We're at 96.74% in that area, which is a full point above the national average of 95.64%. And then in the violation response compliance area, we are at 97.53%. The national average is 91.13%. So those are individuals who are sentenced in New York who are being supervised by another state, and that state has submitted a violation report to New York. We have 10 days to respond to that with how we plan to proceed. That was that 97.53%. Are there any questions about the probation data or the state data? Okay. Yeah.
So our office is slightly different than Kelly's in that I have a full complement of staff, and we do all our electronic transmissions under the ICOT system. Our field officers do the supervision, but they relay the information to us, and then we send it off to the other states. So I think I'm in a little bit of a better spot than Kelly was staffing wise. So our numbers look really good because I have really good staff there that keeps a close eye on it. So our case closure compliance was 100%. The national average was 96.52%. The case closure reply compliance, we were at 97.12. The national average was 92.76. The progress report compliance, we were at 100%. The national average was 92.12%. The reporting instructions were at 97.13. The national average was 97.29. The transfer reply compliance, we were 99.15, and the national average was 95.43. And the violation response, we were 98.15, where the national average was 90.93.
Can you just give us a little bit, I kind of explained the probation process, what that would look like? What does it look like on the parole transfer? Like, what do you see?
So a lot of our transfers are, we don't get the reporting instructions, the amount that you guys get, because ours are releases from prison mostly. So we'll get the transfer requests well in advance of, for the most part, of parolees getting released from their prisons, or we send them out well in advance. We do have occasions with the reporting instructions, but mostly it's under the MOU that we love. And the MOU cases are really probation cases, and they meet a certain criteria, but we supervise them, I think, based on because they're probably considered closer to parolees than they would be probationers as far as like violence and severity of their crimes. But so ours is a little bit different. And again, I got a remarkable office of staff over there, and I have 2 supervisors that keep an eye on it myself. So we're well staffed, and our staff is we have six parole officers, and they're assigned to each certain states, where I don't think that you guys have that luxury. So I also have clerical staff that are assigned to all cases going out, and I have another set that are assigned to all cases coming in. So we got a lot of eyes on the cases going out and coming in, so that's why our numbers look the way they do. Plus, we have less cases than probation too, so our numbers are look a little bit better, but they really it's all relative to the amount of staff that we have in our interstate office.
So Scott raised a good point. Like probation and parole are used kind of, we know what we call it in New York State. We have kind of an idea. Anybody who serves a year or more in state incarceration is going to come out on parole. Probation is generally an alternative to incarceration that they use, although they can do a short term of incarceration at a local jail, and then they're on probation. Other states may see that differently. And so a lot of times we'll get somebody who's on probation who really in New York State, if they were sentenced similarly in New York State, would end up on parole. So that's why we have an MOU with New York State docs to make sure that those individuals that would be coming into New York State are treated the same way that we would treat individuals who are sentenced in New York State. So that's kind of what Scott alluded to, and I know Scott's been a big fan of the MOU. So.
And our level of supervision, I think, may be a little bit more intense because of the status of these cases too, because they're on parole and released from prison as opposed to an alternative sentence. So it is a little bit of a different animal between the two.
But again, great work on both Scott and Kelly's behalf, and both on their unit staff. They're doing a wonderful job of making sure that we're in compliance, because there's this compliance committee, and I'm a new member. I was on the rules committee, finishing up Bob Macaron's turn, and I'm now on the compliance committee, and they're pretty serious about the business about keeping states compliant. I've seen states be fined $100,000 for non-compliance. Luckily, the commission always gives them an opportunity to do a corrective action plan before the fine is imposed. But certainly in the federal district court down in Kentucky, states can be brought down there for non-compliance issues. I do want to speak just one more thing about compliance. Compliance just isn't these 6 measures. Compliance is a lot more than that for states, including, are you treating people as similarly in your state as you would treat somebody who was sentenced in your state? That's one of the big challenges that I know we have, and we've worked very hard on our probation end, because a lot of time probation, if they get an interstate case in, they look, oh, I don't have to take this. This isn't my case. This is, this person, although they are somebody who's lived in their community for a long time, they just happen to go to another state to commit a crime and be convicted and sentenced. So we worked very hard about, making sure that we are treating individual sentenced through the Interstate Compact as we would our own kind of people, because they are people in our community. But there's a variety of things that the compliance committee looks at as far as compliance. And luckily, since I've been here, Kelly's been here for like 40 years. She's really like 70 years old. But luckily, since I've been here, New York State's been very, very good at staying on the right side of the compliance committee and haven't had any issues. So I think that's important to note, because it just notes not only the work our offices, but the office of the probation of 57 county probation departments in the city of New York, being number 58, doing wonderful work in that area. And Scott's and New York State Parole Docs is doing great things too. So I just want to make sure we recognize that compliance just isn't captured in these 6 measures. Any questions? Hearing none, if I can find mine. Yep. So every year, the commission brings together all the states, all the participating states in the compact and territories to one place, and they have what's called the annual business meeting. It's an opportunity for all the states to come together to review any emerging trends, issues, and really get a face-to-face 2-day conference to talk about those. This past year, it was held in Scottsdale, Arizona, where it never went below 104 degrees.
It was
So I think they do a good job of spreading it out across the country each year. One of the things that's done at the ABM is opportunity for states to get together and vote on any new rule proposals that are brought forth. And as I said, it's also time to look at emerging trends, do some training, meet each other, collaborate, things like that. So this year it was held in September in Scottsdale, and Kelly's just going to kind of go over some of the things that happened at this year's annual business meeting in Scottsdale, other than
it was very hot. So at the annual business meeting, there were a few topics that were touched upon. State compliance was one of them. They talked about, why compliance is important, not just number wise, but what's behind the numbers. People who are waiting to transfer. Victims who are out there wanting. There are a lot of things that behind the numbers that we talked about, and why it's important that states remain compliant. We also talked about the tools that are available to states to assist in ensuring compliance. We have access to a number of reports that we can run that are generated from the database that we use nationally to transfer cases. There's also some tools that the national office has put together that states can use. And they also do, national office conducts audits and assessments to kind of assist states in identifying areas where they might need to be addressing procedures and things like that. So we kind of touched on those topics at the ABM. But most importantly, and I think that a large focus of the meeting was surrounding 4 areas that have come up in discussions and meetings throughout the year of areas of potential improvement. And so we had kind of a round robin. They kind of refer to it as a speed dating kind of session, where we broke up into groups. It was deputy compact administrators and commissioners that were in attendance, broke up into groups and discussed these 4 areas. They were probable cause hearings, absconder issues, and then there is reporting instructions for individuals who were living in the receiving state at time of sentencing, with a focus on a disposition of violation, which I'll get into a little bit. And then revocation and retaking after a new conviction and supervision sentence in the receiving state. So those were kind of the 4 hot topic areas that have been of concern, or areas that have been identified by states as areas that need improvement. So with probable cause hearings, our discussion really was surrounding our current rules with regards to probable cause hearings, and do our rules meet the needs of the states and the individuals who are subject to return to the sending state on the violation of probation. The absconder, I don't know if you want to elaborate.
Just to, give a little bit more of what a probable cause hearing is and where it's used in the world of interstate compact. So anytime somebody's subject to retaking and they have to be looking at incarceration, back then retaking is the extradition process of, in my scenario where I went down to Florida, Florida remains jurisdiction, it has jurisdiction, so if I violated in certain situations, Florida would have to come and get me and bring me back to Florida. That's what they call retake. I should be afforded the opportunity for a probable cause hearing in New York State based on the allegations of, brought against me around the violation. And so they have what's called a probable cause hearing. It's generally a third party, unattached third party should be able to sit and listen to the allegations that are brought against me. And it's not a hearing of guilt or innocence. It's just enough to say, yes, there's the likelihood that these violations took place, and this person should be retaken by Florida. As I said, it's not a court process. Matter of fact, the commission is trying to keep it out of the court process. So what we have probation officers usually do is they bring a supervisor in from a different unit who doesn't have anything to do with the case, who sits and listens to the allegations brought against the individual. That individual has the opportunity to be, I think, to hear those and provide any defense against those. It has to be, there's certain requirements. Judge, you'll have the whole bunch book, so we'll ask you to give a better overview of it next time. But again, what a lot of the challenge we have is it's not a violation of probation hearing. It is a probable cause to see if there's enough evidence there that the allegations likely happened, and that person should be brought back to the state. In my example, brought back to the state of Florida. So there's a rule on this probable cause hearing, and it's a pretty big rule for such as there's not a lot of probable cause hearings happening in New York State, at least on probation end, but we're really turning that around where we're asking departments to do probable cause hearings. But so a lot of states have struggled with the rule. The one thing it said that if probable cause is found, that person needs to be immediately taken into custody and lodged awaiting retaking. In probation officers don't necessarily have, they act on the court's authority. So they'd have to go to court, ask for a warrant, have a warrant issued, and then take that person into custody. So we weren't meeting that. So a lot of those types of issues were prevalent, and that was one of the things that were raised and talked about. But
just a quick question: these probable cause hearings are done internally in the Department of Probation?
yes,
Ours are slightly different. So we have administrative, under the chair of towns, there's hearing officers and they're lawyers. So they hear the case, and the parolees are entitled to an attorney at the hearing for ours. That's how we handle it.
I think that was my next question. Sorry, I don't mean to interrupt you. That was my next question. Are the, probationers entitled to an attorney or representation?
If they choose.
yeah.
So they all get one under parole unless they waive the hearing.
They do have the opportunity to
Yeah.
waive.
If it's determined that the parolee or probationer should go back to I guess,
Sending
state, right, who takes custody? Where are they held, or are they immediately?
They're held, and they can be held for up to 30 days. And the probation, and I'm sure probably in the parole, say it's the local jail, the county jail. The sending state has 30 days to come and take that person and bring that back.
The other topic was the issue of declaring an individual an absconder. Most states we found through discussion have a time frame associated in their own states for declaring an individual an absconder from supervision, but the compact rules are kind of silent to timeframes. So, you know, we've been running into or seeing cases where maybe somebody failed to report to probation on Monday, and on Friday, the receiving state is submitting an absconder violation saying they're an absconder. And so, you know, we've been finding that that's happening quite frequently. And then, you know, as a requirement under the rule, the sending state is obligated to issue a full extradition warrant for that person. So we found that, you know, the sending states are getting the warrant, and then the person shows up 3 days later and said, oh, I was, you know, whatever reason they didn't make it. But so there are a number of issues that were discussed about absconders and the current wording of the rule. You know, should there be a universal time frame that all states have to follow before declaring somebody an absconder? You know, do they, or if they already have a time frame, you know, what is the majority of the timeframes in all of the states? And so we kind of discussed all of those different things. Also, if our current rule is really sufficient, I mean, we don't want to change a rule just to change a rule. And so we really took a look at our current rules and to see if there was room for improvement in that area. So that was most of the discussion about the absconder issue. But I think through all of the discussions that we've had, I think it really came down to not really being an issue of the wording of our current rules, but more of practice and maybe training issues in certain areas, but also communication with the other states. I think a lot of times we're dealing with, and I don't know if it had been made clear, and I know that you're new to this whole process. So we deal with, and I know I've mentioned that we deal with the probation departments here in New York on a regular basis. But we're also dealing with the compact offices in the other states. And so, you know, is it just a matter of reaching out to that other state and saying, hey, we've come across this issue, you know, how do you want to handle it type of situation, versus changing the federal guidelines and rules surrounding declaring somebody an absconder. So that was really a bulk of that conversation. For reporting instructions for those living in the receiving state at time of sentencing, this is this discussion gets heated, I think, amongst the people who are in this group. And without getting too far into the rules allow for somebody who was living in the receiving state at time of sentencing or at the disposition of a violation to immediately go back to their home in the receiving state. There's been recent guidance that says that the plain language of the rule allows people who at the disposition of a violation to return to their home, that would apply to any violations, when that rule was intended for people who were returned to the sending state under the compact rules. Their violation was disposed of and then they were transferring back because they were continued on supervision. So I don't know if I explained that.
Yeah.
in general.
My example, when I talked about, when I was here and I got violated, I had to go back to Florida. Well, Florida now heard my case and said, okay, Matt China, don't do that again. Or they gave me 5 days in jail. And they said, we're putting you back on probation. We're restoring you to probation. You still got time left in your sentence. Right now, under those circumstances, I'd have to wait another 45 days to come back to New York, because this is where I'm living, if they were to submit a violation. So they're at disposition of violation, they can ask for reporting instructions and I can immediately come back home. Because this is where I'm going to be most successful in New York. So we want to make sure we're doing everything we can. So that's kind of what it was always intended to do. So if I was retaken from New York, brought back to Florida, Florida judge said, okay, don't do that again. I'm keeping you on probation. That allows me to come right back home where I'd be most successful. What we were seeing was, Matt Charton had no ties to New York at all. He was down in Florida. He was in violation. Well, let's say I absconded to New York, right? I took off from Florida, absconded to New York. I had no ties here, but I ended up here. They found me in New York, Florida did. They brought me back to Florida, and now they disposed of my violation, said don't do it again. Now I can come back to New York automatically, even though I had no ties. I wasn't transferred here. I just ended up here. And really, New York is put in a position where we're now get this person who's been non-compliant. We don't know anything about them. If there's a victim in the crime, we don't know anything about where the victim is. We don't really know about risk levels, so we don't know any of that stuff. And suddenly he's in our state, and we have to supervise this individual without the opportunity to really get that transfer and request investigation, take our time to look and see all the safety factors, risk factors, all that. I'm just back, I'm in your state, and here I am. So you can imagine there are cases, a lot of domestic violence cases we really worry about. Are they tracking, following the victim? Is there victims in the area? Is there orders of protection? Are there VIRs available? So we really want that opportunity to look at that, say to the state, we don't think it's appropriate that he or she needs to return. So that's what we were finding ourselves in. The latter was what we were really concerned about, where he had Matt Chart had no ties to New York State, just ended up here because he absconded here, and now New York State has to accept this person under reporting instructions and allow me to remain in the community until a full investigation comes in. Kelly and I often talk about, it's hard to talk about the interstate compact without really getting deeper into the details, which we recognize that, the membership of this council will be like, we'll be over there snoozing, but it's hard for us to not dig into the details because we want to make sure people really understand it. So that's kind of the issue with the reporting instructions that Kelly was talking about.
Yeah, and I think it's probably nationally split 50-50 on, half of the country is feeling like those individuals should qualify and half don't. So that's an area that I think is still going to be up for discussion until there's a rule change, I would think. So, and then finally, there was the revocation and retaking after a new conviction and supervision sentence imposed by the receiving state. So if there was an individual being supervised in the receiving state, they committed a new felony or violent crime conviction during that supervision period, that resulted in a sentence of supervision in the receiving state. Should the receiving state be sending that person back to the sending state and requesting revocation in the sending state's case? Is that practical? Are there any issues with that? What are the issues with that scenario? So that was another area that, we've been seeing an increased number of violation reports that require them to go back to the sending state when they have, a new supervision sentence in the receiving state. So, we participated in group discussions surrounding these different areas, and, we were asked to consider if states were making decisions based on opportunity and support over, whatever reason, qualifying reason they might have to transfer. are we incorporating the risk needs and responsivity in retaking decisions? Are we ensuring that evidence-based practices are being used? And so they were lengthy discussions. And it happened over 2 days. The DCAs met first and kind of discussed all of those issues and what we see as practitioners in those areas. And then when the commissioners also joined in the discussions on the following day. And so that brought a different kind of level of expertise and different viewpoints on those areas. So we reviewed potential rules, any rules that had already been submitted by regions or different committees of the commission to kind of address those areas and discuss those proposals, if there were any changes that might make those proposals better, if they're necessary, and things of that nature. So there was good discussion. It also gave us the opportunity to kind of engage with states that maybe we don't engage with on a regular basis. We obviously have a lot of dealing with the states on the East Coast, but we do very little work with the states in the West and Midwest. So it was nice to kind of get their perspective on different rules and situations that they run into. So I think it was pretty productive, although I don't know that the East region ultimately had any kind of rule proposals that came out of those discussions as of right now. There is one with regards to the probable cause hearings, but from the state of Pennsylvania. But it was fruitful, I think. Yeah.
And one of the things, and this is where I think the council and the advisory could really be helpful, is we're faced with, one, the Interstate Compact wants to get people to where they're going to be most successful under supervision. That's kind of what we really look at through the lens. All right? But doing that, there are these rules that have the full force and effect of federal law that dictate how that should be done. And sometimes those two notions are contradictory. Like the rules don't allow it, but listen, this is the best place that they can be. And then the third factor is, are we putting victims at risk by just allowing people to go where they want to go without really allowing states to fully investigate those circumstances? So those are sometimes some clashing thoughts, like we want to get that person to New York, this is where you're going to be most successful. Okay, but we have to follow the rules to get him there. We have to allow New York parole or probation to do a full investigation. We have to be conscious of if this is a victim crime, are there existing victims in New York, are there potential victims so all those things is really where, and I think that's the struggle with a compact. They have some old schoolers that say it's the rules. If it doesn't fit the rule, then I'm going to deny the case, even though the person, this seems to be where they'll be most successful. But we can deny it, or we're going to deny it because it's not a citizen of our state. And then there are other people who say we just want to get this person to where we think they're going to be, best situated to be successful, regardless of what the rules say. So, that's the struggle that I think the compact today, and the commission today, is really dealing with. So, thoughts on that? Again, doesn't have to be today, but we can really, follow this thread in further meetings. But that's, I think, not that's where these questions derive from. That's what the compact is really dealing with. What's the best way to do that? So that's something I think that the council, the people, the stakeholders, can be really helpful to regarding our council on this and working through.
And finally, in concluding the ABM update, the commission voted at the ABM to approve the language change package that was sent out to council members earlier this spring, I believe. That language package was developed by the Rules Committee and removed the stigmatizing language from the current ICAOS rules. So it was essentially removing the term offender and replacing that term with supervised individual. And those changes were approved by the commission and took effect on November 1st. So that was a quick turnaround time for that, but I think all the work had been done prior, so that was an easy switch over. But so I will send you all a link to the rules with the meeting minutes so that you can take a look at them if you choose.
It's looking to do whatever we can to remove any barriers for people who are under supervision, trying to rebuild their lives, trying to do the right thing. And just, one way that the commission could do that, we do that, remove some stigmatizing language. Yeah, now, assessment.
Moving on to the next agenda item. We're currently in 2025, the national office, instead of doing an official audit on some compliance measures, decided to do an assessment. They're calling it the risk, need, and responsivity assessment, but it is focusing really on individuals who have violated their probation, that the receiving state has submitted a violation report requiring the sending state to retake them. But then they've ended up being continued on supervision and transferred right back to the receiving state. So the commission really wanted to take a deeper look into those cases to find out why, just a little, I guess, background on what a violation report requiring retaking is. And so the violation report requiring retaking should be submitted by the supervising state when that supervised individual has non-compliance that would have resulted in revocation had they been sentenced in the receiving state. So that's the only time that we should really be submitting as a receiving state that violation report requiring retaking. So if we're doing that and we're truly doing that, why are individuals being continued on supervision and transferred back? They should be potentially, their supervision should be revoked and they shouldn't be coming back to the receiving state under the compact. So the commission's really looking to take a deeper dive into those cases to see, what was the transfer reason, what was the risk level that those individuals were being supervised at, what kind of graduated responses or incentives were imposed by the receiving state during the supervision period prior to requesting they be retaken. And there were a couple other areas that they were looking into, but each state had been given a sample number of cases to look at, and then we would answer a survey and send back the information to the national office so that they can review that and to see if there are areas that we might improve with regards to practice and making sure that we're really applying the compact rules the way that they should be applied. So we had a total of 6 cases that we were required to submit responses on. 5 of them were probation supervision cases, and 1 of them came out of parole. And so we've submitted responses in all of them except for 1 case. I'm still waiting for information from the supervising department on that 1 case, because our office is at a disadvantage in that we don't have access to, their case notes and things like that. So we don't really know what has transpired in the case other than what we see has been submitted in the database that we use nationally. So we had to ask the probation departments to provide us with all of this information. So we are still waiting on 1, but that has to be submitted by November 15th. But I think in all of those, all of the probation cases anyway, I think the probation departments had handled the cases pretty well. I mean, there were obviously things that we can improve on. I think a lot of times the probation departments are not updating the sending states regularly or often enough when they are imposing some kind of graduated response or an incentive, in that they wait for the sending state to request a progress report and then they'll provide information. But they're not just doing it as things are happening or being addressed during supervision. So I think that's clear, that's an area that we could, work on with our departments to make sure that they are doing that. I don't know, with the parole case, what, that situation was, but if you want to speak on that.
The guy was arrested for a domestic incident. We notified the sending state via progress report and they issued a warrant.
Yeah,
So we didn't even ask them to retake them. They just retook them, so.
that happens in some of ours also.
That would be what the bulk of what we got was similar. We didn't ask for a retaking, the sending state issued a warrant or asked to have a return. So they missed the mark.
Yeah.
And the opportunity, because I do think, traditionally there's been violations that are submitted that really aren't violations. Like they wouldn't, if that person was sentenced in your own county, or would you really go back to your court and ask for a violation? But because it's an interstate case, they're more likely to, because they don't have to go in and talk to the judge and tell the judge when he says, what do you mean? This person had one positive urine screen and you want him to go back or her go back to jail. And so in those cases, people were just they were going to Florida, they were judges like, wait a minute, I'm putting you back on probation and now you're going back. We spent a lot of time, we interrupted this person's lives, the state spent a lot of money taking people back and forth, just to have the person back at your door. So that's what they're trying to really get at here, to make sure when you file a violation, this is truly something you think would be a revocable offense and this person should be, incarcerated for. So that's really what they're trying to, I think, get out of this assessment. So, but I think, as Kevin Scott said, a lot of times it wasn't the receiving state asking for a violation; it was the sending state, coming and getting them out there.
In the sending state, you order them or take them back whenever they want. So they have much discretion on it.
Yeah. I mean, I don't know how the violations are submitted in parole, but for probation, our office is reviewing every violation report that comes into our office before it goes to the sending state to make sure that everything is included, that it truly meets that threshold of submission. And so I was pretty confident that the ones that we had would be okay, that there wouldn't be any, real issues with the violations. But again, we're kind of at a disadvantage, I think, at probation because probation is administered at the county level. Every county is so different. And so what might meet that threshold in, Rensselaer County, doesn't in New York City. So, we really do work with the departments a lot to make sure that they are submitting true violations, but we also have no control over the outcome in the courts and the sending state. So, I don't.
Really interesting.
Ours is slightly different than yours, Kelly. So ours is statewide. So if we do a violation, they get a probable cause hearing just like our guys would or girls would get it. And then if probable cause is found, they send it to our office. We then review it and then send it out to the state. If we do a violation in New York State, every one of them will get a preliminary probable cause hearing. And then our office then reviews it and sends it out. But we're fortunate to have our own violation unit, extradition team. So we have, we got a lot more resources than you guys have. So
Well, I will say, Scott, actually, in the juvenile, we have OCFS as kind of our parole counterpart, and they do all the retakings for probation. So if you guys are often do.
Yeah.
you'll have to talk to someone higher than me.
But somebody can record that on the video. Scott.
I'll have to run that by the commissioner.
That is true. Maybe we can work something out.
So, any questions on self-assessment? I think in general we did pretty good. So I was happy with the result of that. Happy about that. Moving on, we always like to kind of put a agenda item as our focal issues, if there's anything that, you know, our offices are seeing as a challenge or looking to lean a little bit on council membership, or if there's something that the council membership is seeing where they need feedback from our office. I just, a couple of just things I should have talked about at the beginning. I've said it 1,000 times, you know, with new membership, you know, the compact, the rules are, you have the full force and effect of federal law, the promulgated rules of the compact, they supersede any conflicting state or local law. And it's not just the executive branch that's subject to the compact. It's the you know, it's the judicial branch. So that's one of the things that we really have a struggle with, where some judges say, well, you know, this is my ruling. You know, it doesn't matter if there's something else. To really get some courts to understand that the compact is really something that New York State signed on to it, the legislature signed, you know, Executive Law 259 and we agreed to follow and enforce the promulgated rules of the compact. So, you know, as in doing so, all these rules don't just apply to the executive, probation, and parole end. They apply to, you know, the jails, the prisons, the judges, the DAs, the defense. Everybody has to agree in New York State if you're doing business to follow the rules of the interstate compact. So that's something that we find on probation, you know, that's a little bit challenging around jail administrators, sheriff's office having to go to Florida to pick people up and spending 75% of their extradition budget on one retake, where the person was only in New York State for a half a second to be arrested, convicted, and sentenced. So it is a bit of a challenge. That's important for to reinforce here for the council membership. But anything that you guys have, or anybody, Scott or Kelly, that you have, this is the opportunity to raise.
Just on the point of retaking and the expenses that the counties or the probation departments are incurring because of the mandatory retakings, we plan to send out a survey to the county probation departments early in 2025 to determine the financial impact of retaking on their departments. So I wanted to wait until 2024, till the end of 2024, to see how many retakings we had completed in the year, and then send them a survey to see if they can give us some numbers so we can really see, you know, what kind of burden that is on the counties, and, you know, if there is some kind of potential for some kind of relief somewhere. We're not sure what that might look. I'm not sure what that might look like, or if there is anything, but just to see what that looks like, because I don't think that there's any hard numbers or facts on that right now. So
yeah. It's something that the commission doesn't collect, so we're trying to do it kind of stay focused about how much our probation departments are being asked to spend on the retaking of individuals. And again, I like in real terms, if I'm an Arizona resident and I just came to New York to, you know, to deliver some drugs or something that's going to result in me being arrested, convicted, and sentenced to a period of probation, and I've got no ties to New York. I was just here to commit my crime, but I'm put on probation, and I go back to Arizona where I lived my whole life, and I'm not successful in my probation in Arizona. And Arizona is now telling New York, you have to come get this person and bring him back to New York. That's a big expense for Cortland County, who, you know, the sheriff doesn't have, DA's office doesn't have a big extradition budget, doesn't have the department team, so they have to contract either the sheriffs have to do it, or so it's a large investment to bring somebody back from Arizona and to face the consequences of a violation of probation in Cortland County Court, where in fact, you know, that person could be just, you know, the probation could be revoked, and that could be it, and time served, things like that. So that's where we're looking to really provide some relief, you know, We want to get an idea of how much counties are spending in New York State, because it is a large expense for small counties, and we recognize the county. That's where we get in some tug of war with those counties. Like, well, we're not going to go get him. He's not a Cortland County resident. He just was here to commit the crime. Now we have to go spend all that money to bring him back. We just want to dismiss the violation, but they can't because the rules won't allow for that. So they have to. New York State and Cortland County, has to, by federal law, go to Arizona, pick this person up and bring him or her back to Cortland County. So you can imagine that puts a big strain on financial responsibility of the county.
Just another question. I'm so sorry. Given the technology we have now, is there a way to conduct those proceedings virtually?
It's something that the commission is recognizing and really contemplating right now. But the rules require that person to be retaken, which is the act of going, getting that person and bringing them back. A lot of that conversation is happening at the national level with that and with reporting instructions, because the person sentenced there, they have to come, now they have to, come back to the sending state and now wait to be able to get approval to come back to where they were sent. So there's a lot of things around remote sentencing, especially with COVID, and that was a lot of how business was done through remote. And now we're saying, well, why can't we just do that now? It just makes more sense, but the rules don't allow for that at this time. And there are some states that, no, I want this person violated their probation. I want you to pick him or her up and bring him back to your state, even though he or she doesn't have anything there. Everything's in our state, but they want that, that idea of punishing that person and making that person go back. So that's a great question, and probably maybe Kelly or Scott have some good thoughts, better thoughts on that.
I don't. It does come up frequently, and that there's actually a white paper that was issued that says that a discharge from supervision in lieu of retaking is a violation of the compact, and I think that kind of speaks to the same process that was happening. I don't know that there was an actual virtual hearing in that process, but it is something that has come up frequently, more specifically with technical violations than, if there's a new conviction, or if there's a new conviction, there's actually a rule that was written to allow the sentence imposed by the receiving state for the new conviction to satisfy the violation. And so that would obviously alleviate the need to have to retake that person. But for the technical violations, it's really a struggle, especially because, and I think that's part of this assessment that they're doing, because some of the violations are not really meeting that threshold or don't appear to meet the threshold for submission and revocation in the sending state. And so I guess the other piece to that, and the part that I find to be the most difficult, is that our counties are often retaking those people, and they can be ordered to return. No, I'm not retaking. They can be ordered to return, which most of them do on their own, but they have to remain in the sending state until that violation's been disposed of, and that rarely happens at their initial hearing. So that's the part that we run into the most issue with, is that, okay, we brought them back, but now they're hearing, the violation's been adjourned for 2 months or whatever it is. So what are we supposed to do now with them for 2 months? They're a resident of your state. So those are the kind of issues that we run into the most. So, I mean, I think that even if it's initial, I mean, I don't know how you would, if it were the initial hearing was virtual, and then, I don't even know how that would work, but I think it could be beneficial in some cases. But, yeah.
No, it certainly could, and it makes sense to sometimes do remote. But if a violation is submitted that it should be, the state saying, we've exhausted everything we have, there's nothing else we can do with that. he's out of control. And you really need to bring him back to your state address that is not compliant. So if you do a remote, that child gets to stay in that state and continue my reign of terror over that state. And so that's really what that kind of balance that we try to find in doing that. So yeah, so that's a struggle on both ends. Thank you. Questions? All right. I don't know if anybody here, I do like to go around and kind of have each member give updates on anything they'd like to update us. We kind of did that in the beginning with our introductions, but I would ask if anybody here has an update they want to share, something you're doing, you want the council to know about. Anybody? Yeah.
I think it's worthwhile, as I mentioned at the beginning of the meeting, we administer the federal funds for both compensation and victim assistance programs. We are right now putting together a draft of RFP for the upcoming contract period to be determined for the federal funds that should be coming out in early part of 25, hopefully before the end of January. So we're able to get our victim assistance programs who are currently funded, any new victim assistance programs who are looking for funding to get their applications in and have those contracts in place by the beginning of the federal fiscal year 25.
Okay. And that RFP is not out yet. You're still.
No, it is not. If it was out, I probably wouldn't be talking about it.
That's true. That's true. That is true. We wouldn't talk about it. Lisa, do you have anything? No.
No, just working hard.
Anybody? I don't want to go around the room if nobody's got anything. Under new business, I will say that the real proposal next annual business meeting is going to be held in Puerto Rico for I think the first time ever that it's being held in Puerto Rico. So you can come along with us down to the annual business meeting next September. But there's going to be a real proposal year. So we will be hopefully in May, we may have some initial real proposals to present to the council for your review and feedback. If not, we'll try to schedule our fall meeting before the actual annual business meeting so we can make sure that the council is well aware of what real proposals will be put before the commission to be voted on. So we'll try to do that. If not, we'll certainly get them to the membership electronically, which has the opportunity to look at what those proposals are. Certainly, if the council membership has anything that they think it doesn't have to be actually a proposal, just an area that we'd like your state to look at, and maybe develop some rules on. We're certainly open for that, so we're happy to listen to the council membership in that area. But other than that, I don't have any new business. Kelly, do you have any business? All right. Well, our next meeting will be in May of 2025. We'll get that date. I know we're trying to identify a date as soon as we can because the calendar is busy, so we'll try to get a date identified in May. And anybody last minute questions, concerns, or issues? Having heard that, having heard none, I will entertain a motion to close out our fall 2024 council meeting. Salazar moves. Thank you all. I really appreciate the work that you guys continue to do in the support of this council. Thank you very much. Thank you.
Yeah. Yeah.